Welcome back. Now we're going to continue to talk about the evolution of federal preservation law. The Bureau of Ethnology was created in 1879 by the one-armed John Wesley Powell, who you might know from his expedition down the Colorado River. The Bureau of Ethnology was created to support and facilitate a growing interest in American prehistory. By prehistory, the Bureau primarily meant studying Native Americans. It sponsored projects in the West and Southwest and served as a kind of intermediary between the Smithsonian and the Department of the Interior. Powell's goal was organizing and curating all of the anthropological research in the country. The Bureau conducted ethnographic research, archaeological and linguistic field studies. It published annual reports and field studies and prepared museum exhibits. In addition to its own collection and curation efforts, it also served as a repository for the documents on American Indians collected by other organizations like USGS. Powell and others at the Smithsonian were working hard to try and keep up with all of the discoveries that were being made out west, using the term discovery very loosely. But there was no regulation of archaeology up to this point. With no laws protecting these cultural resources, looters took over the Southwest. And the most successful of these was Richard Wetherill. Wetherill was a rancher from Colorado who, along with his brothers, excavated literally tons of ruins in the Southwest. He developed the idea of relic hunting as a cottage industry. The problem with these types of excavations was that there were no standards for private excavations. Wetherill wasn't accountable to anyone, which was a problem because he knew about the location of more ruins than anyone else. He was also only in it for the money. He actually formed a relationship with the American Museum of Natural History in New York City and made thousands of dollars from excavations in the 1800s at Mesa Verde, Chaco Canyon, and Casa Verde. And the Wetherills were not the only pot hunters out there, but they were the most successful. And this would breed contempt from experts, who would then begin to put pressure on government and professional organizations to begin to seek regulation. By the late 1800s, the American West was closed. There was no longer the same push for westward expansion. Instead, focus shifted to filling in the gaps in existing development. The government also started to recognize the need to conserve natural resources to prevent what had previously been haphazard exploitation, particularly of the lands out west. There had been a lot of natural resources that had been decimated. Buffalo, fish, trees, the wilderness had been plundered by settlement. So the federal government, in an effort to slow things down to a more reasonable pace, first came up with the General Revision Act, which created and funded forest reserves. Now, these first actions were for natural resource management and conservation, albeit a very different type of conservation than what we understand today. There were also a number of proposed congressional actions to try and control what was happening out west, such as making reservations of land for the public interest, protecting things like historic and prehistoric places, and natural or scenic areas. People out west didn't like this idea, though, because there was too much restriction on land they wanted to use. Congressional resolutions were also proposed to punish pot hunters. These measures all gave the federal government different levels of authority, but ultimately all of these measures died in Congress because Western congressmen objected. These men were still trying to encourage settlement and trying to support the financial interests of their constituents, who were making quite a lot of money from these artifacts. Back in the East, the courts were weighing the benefit of preserving dignity and patriotism over tourism and economics in United States v. Gettysburg Electric Railway Company. This is the first actual historic preservation Supreme Court case. Congress had authorized the creation of a park to commemorate the Battle of Gettysburg. Unfortunately, the Gettysburg Electric Company already owned a railroad that went right through the park's boundaries. Congress passed a resolution authorizing the purchase of the land from the railroad using eminent domain. But Gettysburg Electric didn't want to sell and sued to keep the land. The company argued that nothing in the Constitution gave Congress the power to take the land. But the Supreme Court found that any act of Congress which plainly and directly tends to enhance the respect and love of the citizen for the institutions of his country, and to quicken and strengthen his motives to defend them, and which is germane to, and intimately connected with, and appropriate to, the exercise of some one or all of the powers granted by Congress, must be valid. The court was a little fuzzy on specifically why this was constitutional. They agreed that the power of condemnation was not explicitly given in the Constitution, but found that the power was implied because of its necessity. Although they didn't explicitly say the necessary and proper clause was the justification, it's implied. Heading back out west, exploration and looting continued. Casa Grande was another significant archaeological site that had been explored and exploited starting in the 18th century and throughout the 19th century. During the 1860s through the 1880s, more and more people began to visit the ruins after a railroad line was completed 20 miles to the west and a connecting stagecoach route began running right past the site. The damage from souvenir hunting, graffiti, and general vandalism raised concerns about the fate of Casa Grande. Anthropologists and historians from Massachusetts visited the ruins in 1883 and reported back on its condition and significance, urging their senator to petition the Congress to take steps to repair and protect the site. Repair work began the following year. In 1892, President Harrison set aside 1 square mile of Arizona territory surrounding Casa Grande to protect this archaeologically significant place. Meanwhile, the Wetherill crew, along with numerous other looters, continued to plunder the West. Newspapers reported on his Chaco Canyon digs, calling it a raid on ruins by professional pot hunters. Wetherill alone raked in over $80,000 in stock, all of which was donated to museums in New York. But whose right was it to make those donations? If the mineral, timber, and other rights on federal lands belonged to the federal government, why not the artifacts? This is what the General Land Office in particular was taking issue with. However, there was no law at the time that could specifically stop these excavations. The government got creative in stopping Wetherill, actually using the Homestead Act of 1862. He'd taken out a homestead on this land, but because he hadn't planted crops on a sufficient amount of acreage to satisfy the law, his right to use the land was revoked. Now, despite stopping Wetherill, there were still thousands of artifacts being removed from these sites, and the remaining plunderers needed to be dealt with. Enter Theodore Roosevelt on his white horse with his progressive ideals. With Roosevelt, there's no more 19th century American idea of doing what you want, when you want, where you want. This was a man that loved, well, everything. He was an avid naturalist. He wrote papers and books on politics, wildlife, and frontier history. He was well-traveled, well-educated, and well-read. His family had a history of creating social programs in New York. The Roosevelt family was also responsible for establishing the Museum of Natural History in New York City that was buying up many of the artifacts being plundered out west. Roosevelt's conservation ethic became a big part of his progressive reform, and he would oversee the General Land Office stepping up regulations on permitting excavations on federal lands to individuals without scientific credentials. And these limitations would eventually lead to the creation of the Antiquities Act. The tipping point for enacting this law came with the discovery of a small, simple pot in Sequoia National Park on August 25, 1904. U.S. Army General George Hamilton, the superintendent of Sequoia National Park, wrote a letter to the Secretary of Interior, Ethan Hitchcock, explaining that a worker in an unfrequented part of the park found a prehistoric stone dish, roughly gouged out of a piece of soft stone. Of course, this wasn't the first time this type of object had been found in the park, but Hamilton refused to leave such discoveries to chance. And because he expected more Indian relics would be found, he asked the secretary for guidance. Hitchcock, along with acting secretary Thomas Ryan, responded to Hamilton, directing him to get the dish back. They asserted the artifact needed to be returned to the superintendent, and ordered that people were no longer allowed to take artifacts off government land. This was the first kind of general order to protect prehistoric ruins and artifacts in the public domain. The dish also caught the attention of Richard Rathburn at the Smithsonian. Rathburn asked that the artifact be passed along to him for research purposes. While the pot was in Washington, it caught the attention of William Harris, the acting commissioner of the Bureau of Ethnology, and Charles Walcott of the USGS. These men also suggested that there needed to be some type of legislation mandating people to get government authorization to comb federal lands for artifacts. They thought this permit system could be governed by the Smithsonian and the Bureau of Ethnology. The General Land Office suggested that looters should be charged with trespassing. And in addition to the question of who was allowed to dig, these individuals wanted to address the question of what they got to keep and who owned the artifacts that were discovered on public lands. The concern was raised that if people were allowed to keep whatever they found on federal lands, and if people were allowed to dig without scientific standards, there would be a negative impact on scientific efforts to understand prehistory. Again, there was no existing law that could establish that artifacts found on government land belonged to the government, or indeed to the Native American tribes they actually belonged to. The man who had found the stone pot refused to give it up. Technically, it was illegal to keep the artifact. There was nothing in place that would allow anyone to seize the dish, arrest the pot hunter, or even keep him from leaving California with the object. All they could do was tell him not to leave. So people finally realized they needed some sort of formal law to protect archaeological heritage. After 2 years of hemming and hawing, in 1906, the Antiquities Act was passed. This was the first general federal law addressing archaeological and historic preservation concerns in the United States. Teddy Roosevelt and his progressive administration were attempting to establish new ways of looking at protecting the public good within the federal system. There were a lot of competing interests that were considered in creating the Antiquities Act. The Land Office wanted to bring order to the western states. Politicians from the western states wanted continued freedom to do what they wanted to do. Others wanted to preserve prehistory as a form of national heritage. Academics wanted standardization and accountability, and obviously wanted to keep people like the Wetherells out of their sandbox. Anthropologists and archaeologists were interested in promoting the study of Native American societies, past and present. And cultural institutions wanted to build up their material collections with artifacts and information of interest and value to the public. Roosevelt wanted to rein things in by promoting his conservation ethic. And on the other side of the issue, popular interest in archaeology began to fuel an international antiquities market where the demand far exceeded the supplies of art and curio dealers, traders, tourists, museums, and thieves. The result of all this was the Antiquities Act.